My name is Phil Worden, and we're going to be here till about 7:45. I plan to do about maybe 30 minutes of speaking, and then we'll have plenty of time for discussion and debate and rebuttal and all that kind of stuff. You know, I want to say I hesitated about putting this program on because I don't want to scare people. You know, a lot of the materials I'm going to cover are in fact scary. And I don't want to paralyze anybody with fear. I have a strong bias that America is going fascist, and that a historic role falls on us to stop it. I think we're going to have to take risks and make sacrifices to prevent the rise of fascism in America. So I don't want to scare anybody away from the types of sacrifices and risks that I think we need to take. I'm inspired by the Vietnamese Look Up campaign. When we first started bombing Vietnam, the peasants were scattered in absolute terror. So the Vietnamese set up a program saying when the bombers come, look up. And they learned to identify each type of plane, what weapons it had, and what kind of damage it could do. This didn't save everybody, but it did save a lot of peasants. And it also overcame the kind of terror that bombing begins. So in the spirit of having the courage to look the beast right in the face without being terrorized, I present to you the harboring statute, 8 U.S.C. 1324. It's one of the statutes that I fear is going to be used against us. I wanted to start off by just saying I didn't want people to get overly assured that just because we're doing 1324 that that'll take care of everything, because it's just one statute of many statutes that could be used against us. But it's the one that I decided to focus in on because I think it's likely to hit for where I believe we're going. So before we jump into 1324, I thought I would just touch on some of the other statutes so you get an idea there's an ocean of law out there, and we're only going to be discussing a drop of it. These are the charges against Judge Dugan. If you remember, Judge Dugan was the judge who had an undocumented defendant in her courtroom. And she knew ICE was out in the hallway waiting to grab him as soon as he came out of the courtroom. So she allowed him to go out to the jury room to avoid ICE. They got him out in the street later anyway. But then they arrested her. And these are the charges they brought against her. You can see, and they're all under Title 18, which is the Federal Criminal Code. 1324, which we're dealing today with, is Title 8. But there's overlap between them. In other words, this statute here of concealing anyone from arrest, or this one, which is obstructing proceedings, such as ICE, but any federal proceeding, these statutes apply to. 1324 is under Title 8, which deals only with immigration law, but has a similar type of statutes that we see that have these kinds of materials in them. First thing I want to start off with is on 1324. A lot of people, when they talk about what they call illegal aliens, is usually about crossing the border. And there's some question about if somebody's already here and living here peacefully, do these statutes apply to them? And the answer is yes, they do. And you can see as early as 1992, there was a court case that held specifically that this stuff that we're going to discuss today applies to people who are already in the United States, whether they came in legally or illegally. Doesn't make any difference. I also included in here a footnote from Justice Jackson's dissent on the Hansen case, which we're going to go into in quite a bit of depth, where she talks about that, and she concedes that yes, it applies to people who are already here. But she says just remaining here isn't sufficient, that they have to do something more, because to induce somebody to do something, you don't normally induce somebody to do what they're already doing. That was in the dissent, so that's not the majority opinion of the U.S. Supreme Court at this point, but I thought I would just bring it up so we could start off with understanding that we are not just talking about people crossing the border illegal, we're talking about people staying here, and as we'll see, it's day by day. Each day is a separate violation, as well as each person is a separate violation. With that, I'll introduce you to the actual 1324. Here it is. Don't try to read it, because I had to reduce the font size to get it to fit on. But I put in red the parts that we're going to focus in on 1324 today. So you can see that we're not, that 1344 is not just a drop in an ocean of laws, but we're only going to be concentrating on just a part of 1324, the part that I think is most relevant to what we want to do, which are these sections here of bringing in and harboring certain aliens. And we'll go by that almost word for word so we really understand what those things are saying. First part of the statute is any person. And I know most of you have your own little private corporations that you're thinking when you have your corporation doing this stuff for you, but corporations count as a person. So bear that in mind. Knowing or in reckless disregard of the fact that the alien has come to, enter, or remains in the United States in violation of law. You'll see this is two different parts. One is knowing, and one is reckless disregard. So in other words, if you know what you're doing is somehow aiding somebody who's not here legally, that's one thing. But even if you say, well, I didn't know his immigration status, if there were grounds for you to know it, and you didn't know it, because you had a conscious disregard of that fact, like almost a need not to know, that does not provide you with a defense. Recklessness is usually defined as a conscious disregard of a known risk. In other words, if there's a possibility that there are illegal aliens out in your group, and you consciously disregard finding that out, you've recklessly disregarded the fact that the alien has come into and remains in the United States in violation of the law. Is conceals, harbors, or shields from detection, or attempts to conceal, harbor, or shields from detection such alien in any place, including any building or any means of transportation. Now the statute does not define what conceals or harbors means. And my sense is that the circuit courts are split on the issue. There's three different approaches that the courts are using toward this. One, which is most favorable to us, says that to conceal or harbor, you have to do an actual act of concealment or harboring. And anything less than that is insufficient for a conviction under this statute. A second approach to that is an intermediate one that says you don't actually have to be involved in the concealing, but if you take a substantial step to facilitate it, you're guilty. And then the third approach, which is the most reactionary, says if you do anything at all that's helpful to a person to stay in the country, you're guilty. Here's a 1975 case, it goes way back, where they're defining it. And they start off with saying, well, it'd be nice if Congress had defined it, but they're going to come up with it. And this is the one I believe that the First Circuit would use. And we're in the First Circuit, for those who aren't familiar with the Circuit Courts of Appeal. So this would probably be the one that would apply to us. I want to caution you, though, that the courts are split on this. And there's no guarantee that the First Amendment, the First Circuit would do this, because the First Circuit has not come out with a definitive case yet in our area. And there's also possibly, even if it does, that at some point the U.S. Supreme Court will decide what is the correct approach to these things. And that will, once the Supreme Court comes in, all the circuits will line up, and that will be it. And there's no way I could predict with a magic ball what the U.S. Supreme Court's going to do. I've got my suspicions, but I just wanted to caution you on that. encourages or induces an alien to reside in the United States. Now, the knowing or reckless disregard part only applies to the conceals and harbor. It does not exist in the encourages or induces an alien to reside in the United States. So there's no need under this language for you to know whether the person is here legally or not. If you do something that encourages or induces them to remain in the country, you're guilty. And some of the examples are fairly far-fetched of a grandmother writing to her grandson in Mexico that she really misses him, and whether that encourages him to come into the United States. Or somebody saying to their mother-in-law who's living in the house, no, you're no burden to us, whether that encourages them. Whether somebody giving a warning about a storm is coming, seek shelter, whether that encourages somebody to remain in the United States. So you can see there's a very broad stretch here of possibilities. We're going to go more in depth in that when we get to the United States Supreme Court case on Hansen, which is the leading case on that, and an interesting way they read that. And engages in any conspiracy to commit any of the preceding acts, or aids or abets the commission of the preceding acts. In other words, this part applies to you even if you're not one of the ones who's concealing it. In a conspiracy, you don't have to know your fellow conspirators, and you don't have to agree to everything they're doing. But if you're in a conspiracy, you're liable for anything any of the conspirators do. And to give you a scary example of that, I don't know if I should or not, but suppose you were in a group, like ice melters or something, that had as a statement that you don't have to do anything you don't feel comfortable doing. That does not provide you a defense against a conspiracy, because if the group is in fact conspiring to impede ICE, all the conspirators, whether they're participating or not in any individual act, are equally guilty. So say like with bank robberies, it's not just that the person who's the lookout, who never goes near the bank, is just as guilty as the guys who go into the bank, but the guys who remained at home and maybe gave them maps about how to get there or anything, they're all part of a conspiracy to do bank robberies, and they're all as guilty as the guys who go into the bank and hold the gun up. Then aiding or abetting, we'll get a little bit more into this with Hansen, is basically helping somebody. So, since we already have this up here, what you're talking about there is aiding and abetting somebody like us who's doing something to help a migrant. So those are very broad, scary kinds of things. I don't know if you remember in the 60s, the Chicago 8 trial. But they didn't know each other, and they never met together, but they were all deemed a part, or at least accused of being part of a conspiracy and all responsible for everything that happened. I think Bobby Steele of the Black Panther Party didn't even go to the Chicago 8 demonstrations, but was equally charged along with everybody else. And here's the fine if you break any of these things. 5 years and a fine. And that's the least punishments that there's enhancements of much more drastic penalties if you profited from what you did or somebody got hurt in the process. Then that's like, but even if nobody gets hurt, you're not profiting, you're facing 5 years, up to 5 years. It doesn't have to be that. U.S. v. Hansen is the leading U.S. Supreme Court case on this stuff right now. It's a 2023 case, so it's just a couple of years ago. And it's a First Amendment case. The reason I want to concentrate on it is when I go on the internet and look around for, like know your rights kind of stuff, they'll often mention this and say, well, 1324 has been subjected to a First Amendment challenge, and the U.S. Supreme Court rejected it. So the First Amendment challenges are kind of over, which I think is a misunderstanding of the case. But before we go into the legal reasoning of Hansen, it's good to know who our plaintiff is, our champion who decided to attack this statute on the First Amendment grounds. And what Hansen did is he went around in the third world, mostly South America, and sold what were known as adult adoptions. He told people that if you got adopted as an adult by an American, you automatically became an American citizen, and you didn't have to worry about immigration. And he was charging about $5,000 a pop for this. He made over $2 million selling these things. And of course, it's all a complete scam because an adult adoption does not get you around the immigration laws. And so it's just a complete scam he's doing this. So he's our guy who we're rooting for, supporting the First Amendment against 1324. And it does make a difference, I think, in terms of how cases are looked at, about who the plaintiffs are and who the people are involved here. Here's probably the most unattractive person you could imagine being our champion for the First Amendment. His challenge was what's known under the First Amendment law as an overbreadth challenge. Overbreadth exists when a statute is so broad that it covers some materials legitimately and other speech that is protected by the First Amendment. So it does both. And if it's overbroad, then they can strike the whole statute down. And here's the reasoning for it. This is from Amy Coney Barrett's Hansen decision. And, she's on the U.S. Supreme Court. And so she just explains that the overbreadth doctrine instructs a court to hold the statute unconstitutional, even though it has lawful applications, and even at the behest of someone to whom the statute can be lawfully applied, such as Hansen. This is what she explains is why the U.S. Supreme Court has adopted the overbreadth analysis. And when you read the case, Justice Thomas writes a concurring opinion saying he would junk overbreadth altogether. He thinks it's judicial activism. But the idea is, if you have an overly broad statute that covers some things that the government can restrict, but other things that the government is not allowed to restrict, it will chill the people who might fall within the protections. In other words, if they read the statute and say, oh my God, I shouldn't do that, then they're chilled and they lose out on the marketplace of ideas. It's saying that the U.S. Supreme Court is trying to encourage people to feel free to speak out. This is First Amendment, basic. And here she's explaining that there's a balancing there. You have to look at how much protected speech is this statute prohibiting versus how much unprotected speech is prohibited. In other words, how much of the statute is good and how much of it is probably unconstitutional. And saying there has to be an imbalance before they're going to strike it down on overbreadth grounds. And here she's going in and saying, well, overbreadth is strong medicine, and so we shouldn't use it casually. And you see that's starting to set up about where we're going to go with this, so that they're not going to hold the statute to be unconstitutional. It's a violation of the First Amendment. Here's how Amy Coney Barrett explains what Hansen is arguing to the court. And she first just cites with the First Amendment saying, and he says that this statute, 1324, punishes so much protected speech that it cannot be applied to anyone, including him, so he should get off. And then Hansen, like the Ninth Circuit was the Court of Appeals that the appeal went from the U.S. Supreme Court for. The Ninth Circuit decided that Hansen, he said, yes, this was an overbroad statute. And now we're going to go into the critical part, where they're talking about the word encourages and induces. And the question is, do we look at those words in the statute in their ordinary meaning, or is some kind of specialized meaning in criminal law? And we'll see where she goes with that. And his primary argument, according to Justice Barrett, is that the encouraging and induces section of the statute does not have something in there saying you must know that the person's in violation of the law or you must intend to violate the law. That Hansen argues that that makes it unconstitutional and a violation of the First Amendment. Here are some quotes from Amy's majority opinion explaining why they're going to reject Hansen's arguments. And she defines the issue as whether or not we're going to look at encourage and induce as terms of art having a special criminal meaning, or whether we're going to see it in the ordinary language that people use what they mean by the words encourage and induce. And she points out, because this is where we're going, that the overbreadth challenge here really only has a chance if we use the ordinary meaning of the words. So that's going to set her up to go into the specialized legal language. And she tells us now where they're going to go. She's going to say that encourages or induces has a special criminal law meaning that really means solicitation and facilitation. Now, solicitation and facilitation are not in the statute, but she's going to read them into the statute to state it. So then she goes into the background of facilitation, everything, and aiding and abetting. And you'll see it's interesting to say that solicitation is complete as soon as the encouragement occurs. In other words, nobody has to actually cross the border or remain or do anything. As soon as you do an encouragement, that's it. Whereas abetting requires that a wrongful act be carried out. And she goes in, and this is important for us to understand when we're dealing with what you don't have to do anything physical. Words alone may be enough to violate the statute. So then she comes down to things that encourage and induce, which is in the statute, actually really means solicitation and facilitation, which is not in the statute. And she just says that several times because she just wants to beat that point home. She says it's a good hint it's in the criminal statute, therefore we should use criminal special meanings. And here she's referring to the Ninth Circuit Court of Appeals, which had granted Hansen this thing and held that the statute was overbroad. And she's going to say what's wrong with that. And it's interesting the language she uses here. She said the Ninth Circuit stacked the deck. Stacking the deck, as far as I know, is cheating in poker. Yeah. You stack the deck. So she's accusing the Circuit Court of Appeals of the Ninth Circuit of stacking the deck. It's like cheating in a poker game, as though this was a poker game. And then goes on to say that they use the ordinary meaning. In other words, that somebody reads the statute and uses their ordinary meaning. That was stacking the deck. And they should have given a specialized meaning a fair shake. So she's accusing the Ninth Circuit of not even being fair in covering this stuff. And she says, when Congress translates a common law term like facilitation and solicitation, which she's bringing into the statute, even though Congress didn't put it in the statute, she said when they did the encouragement, the old soil, she calls it, comes with it. So when Congress passed the encouragement and induces in clause, the traditional intent associated with solicitation and facilitation was part of the package. Then she just summarizes what Hansen would have to show to win that do an overbreadth. He'd have to show that there was more protected speech being covered than there was legitimate things being covered. And says that just isn't the stuff of overbreadth. And she goes through it elsewhere, all the legitimate things. There's a lot of legitimate things about people that bringing in people doing much more than just speech kind of activity. So there are some legitimate coverages there. And she says, but they outweigh the hypothetical things he brings up. And that leads to her ultimate conclusion that 1324 does not violate the First Amendment. I went to look at a post-Hansen case just to see how the courts are doing after this, because Hansen was in 2023. And I found an upstate New York one that seemed pretty interesting to me. What happened in this case is the ICE suspected that there were illegal immigrants working in this factory. So they went and got an administrative warrant and a judicial criminal warrant. Both of them were signed by a magistrate judge. So sometimes you'll hear in some of the stuff, well, administrative warrants aren't the same as judicial warrants, which is not really accurate. There's several different kinds of administrative warrants. So, so it says that the first step here, oh, I forgot. I was going to tell you what was happening this day. So the ICE gets these two warrants, and in their memorandum to the court to get the warrants, they say one of the things they're going to do is they're primarily going in there just searching for business records of who's employed and who's not employed. That's all. But then they put in there, but that they might consensually question workers who were there in the factory about their immigration status. Police come in, seize everybody, bring them all in a big room and say, for all of you who are U.S. citizens, you go over here. For those of you who are not U.S. citizens, go over there. For those of you who are refusing to tell us, you go over here. And then they start questioning people, and of course they screw it all up, and people get mixed up in the wrong groups and stuff. But our particular plaintiff in this case was there, and they went to her, and they asked her if she was an American citizen. And what she responded, which was a good response, is, I'd like to see a lawyer. And then they asked her another one, is, do you have papers showing things? And she said again, I'd like to see a lawyer. And that's all. So the court is going through there of what it's supposed to do in this type of situation. And it says they're looking at whether the seizures were reasonable. Because remember, under the Fourth Amendment, it doesn't say you have to have a warrant. What the Fourth Amendment says is that unreasonable searches and seizures are prohibited. So it's the reasonableness of the search. The Supreme Court has held in past cases that if it's a warrantless search, then it's unreasonable unless it fits into one of the exceptions that they drafted, and there's just a ton of exceptions to the warrant requirement. But when they're talking about seizures, don't think they're talking about going and seizing a book or something. We're talking about seizing people. And they say what it takes for them to legally seize a person, like in this factory type of situation. And an investigatory detention, which is just a very brief kind of stop, we call it often Terry stops, which is pat down for weapons, only requires suspicion, but an arrest requires probable cause. And then they go in to what happened here and said, this had nothing to do with what the ICE people told the court. Because the ICE people told the court that they were going to only interrogate people consensually. And in fact, what they did is they ordered people around in groups and demanded questioning and stuff like that. So this court says this was an illegal Fourth Amendment violation for them to do this, and granted her motion to suppress. So she gets off. So you can see the Fourth Amendment is still alive and well, even after Hansen. There are some other issues in the 1324 that aren't terribly important to me, but I thought they might be to some people here, so I just would mention that they exist. One is there's an exemption in 1324 for religious and charitable organizations. But the requirements for that is you can't be paying the person you bring in, and they have to be a member of your church for at least a year before you either encourage them to cross the border to come in to preach in your church, or you bring them in because they've already been there, but they must have been in the church for at least a year. The seizure is another part of the statute, and that might be for interest of anyone who, say, is using a taxi or something like that to transport people around. And what this 1324 says, in addition to the 5 years in fines you can get, they seize whatever was used to commit the crime. So if it was a car, they're going to seize your car as well. And then there's another part there which is just purely evidentiary, but it cuts off a lot of things, saying there's prima facie evidence if any of the following things occur. And it's things like, if an ICE agent gets up there and says, well, he has personal knowledge of this, and the person is in fact undocumented, that's prima facie evidence. And we don't have to go into the rules of evidence because this preempts the rules of evidence. So all that stuff is still in 1324. And that leads me to what I think most people want to know, which is what is to be done? What are we going to do about this? And as I put in the link, is it a felony to help those hiding from ICE? Now, I know some people have been asking me, like, well, what if we bring food? What if we bring transportation? What if we pick up diapers for them? A whole mess of things. And there's not a list of various things that do or don't do. What's being looked at is, are you doing anything that's impeding ICE? That's what's looked at. So if you're bringing food to somebody who's in hiding, that helps them stay in hiding, which is, of course, why we're bringing them food. And that impedes ICE. And so on that type of situation, you're guilty. But if you'll remember, when we got into Hansen, the Hansen court read in the solicitation and facilitation stuff to save the statute. And the main reason they did that was because the wording that they were dealing with did not require criminal intent. So that you brought in the solicitation, facilitation, what that was all about was requiring criminal intent. And then they say, well, now there is criminal intent in the statute, and therefore it survives the First Amendment attack. So the criminal intent becomes very important. So the difference between a humanitarian intent and an impeding ICE intent could be the grounds between a defense for us and not. So imagine a situation where, say, somebody is bringing food down to somebody who's undocumented, and they get caught, and they're on trial, and they get up there and testify and say, yes, I was bringing them food, but I was doing it for humanitarian reasons. It had nothing to do, in my mind, with ICE at all. It's just purely humanitarian, and therefore, I'm not guilty under the statute for doing something that's humanitarian. Now, they don't have to take your word for it, that your intent was humanitarian. They go into proof of that. We'll get into it in a second. So it's important, at least if you want to try to have a defense for this, that you've been doing this for humanitarian reasons, and that you say as much as you can. This is for humanitarian reasons, has nothing to do with your immigration status. We don't even ask what your immigration status. We just feed. All we're looking at is, if you're hungry, we feed you. And that's humanitarian, and we don't care whether ICE likes it or not. I think there's an importance under this, making this kind of a case, of the timing. In other words, if you set up an organization that says it's going to provide food or transportation to migrants, if you wait until ICE is doing raids and stuff like that, and then you do it, it's much harder to get up there and make a case that this wasn't about a criminal intent to impede ICE, because you did it as a reaction to what ICE is doing. So if you want to go that route, it's much better to do it as soon as possible, because the longer the history you have that you've been engaged in these kind of humanitarian activities, the more credible it is that your intent was humanitarian and not to impede ICE. And neutrality on immigration status. Obviously, if you say something like, well, we're doing this for only undocumented people, that's going to be used against you. But if you're neutral on it and say, we're not even inquiring what your immigration status is, we're just feeding or providing transportation to whoever needs it without regard to that, that helps you develop a defense. Now, I don't want to promise you that these defenses will work. It's just as, what we do is we try to dig out of these things the things that we might be able to use. Some other points of evidence are security measures. In other words, if you're in a situation where say somebody's up there and they're testifying, they've been caught, they're in court, and they're testifying, I was doing this just for humanitarian reasons, I had no intent to impede ICE. And then on cross-examination, they say, well, weren't you on the signal chat? Didn't you change your name? Didn't you use code words? And all these kinds of things that they say, that is a consciousness of guilt and can be used against you. So why would you be doing these things unless you believe what you're doing is illegal? So the consciousness of guilt can be a very powerful evidence to be used against us. And I suppose the way I would just reduce this down, because I know a lot of people are into all this security stuff, that to my mind is very likely to backfire on us. But I guess the bottom line would be, if you're going to rely on security measures, make sure they work. Don't get caught. Because if you're caught, you're going to be worse off for having done those security measures than if you didn't. I would much prefer to defend somebody who said, I was out in the open and saying, I'm a humanitarian, I'm out in the open, I have nothing to fear, I'm feeding people, it's independent of their immigration status, and I'm not afraid, I know I'm legally right and I'm going to do it. It's very different than somebody who said, well, I was sneaking around, changing my name and doing all these kinds of things to avoid getting caught. And you say, why would you want to avoid getting caught? And of course, we can deal with this kind of stuff because we would come back with a rebuttal saying, well, what they're really saying is they believe the country is going fascist and that the government was breaking the law and therefore they had to hide from an illegal fascist government that's coming to do that. That's a coherent argument. It's more difficult to make than just the pure one of the innocent person who's out in the open saying, I'm innocent, I'm doing this for humanitarian reasons. But as we take the facts that we're given when we develop a defense. So there is a defense of that, but you ought to be aware of that. So my suggestion is, if you're going to be into the security measures, you better make sure they work, because you'll be worse off if they don't than if you didn't do them at all. Then there's the mission statements can also be used to say what it is your organization was doing. My first impulse was to write out some sample mission statements saying, we're a humanitarian organization, we're neutral in immigration, things like that. But then I thought, boy, that would backfire, because if I put it up there, I'd be assuming there's some police in the audience today. If I was to put up mission statements and then you guys out that, oh, you copied a thing you heard, a thing about how to impede ICE, that would not do well. But I do think that you should use your own wording however is best for you, but it's good to have a mission statement and to have it in your mind when you're writing your mission statement that what you want to do is make it as clear as possible that your intent is humanitarian and not just to impede ICE. And then there's the remaining First Amendment challenges. And I go back to the Hansen case because it's often dismissed as saying, well, there's a First Amendment attack on this statute and it survived. Because that's not really what Justice Barrett was saying. In her very last sentence, he says, Hansen's asked us to throw out too much of the good based on a speculative shot at the bad. That's overbreadth balancing. This is not the stuff of overbreadth. And then she goes on, this is the critical language here. As applied, challenges can take it from here. Now, as applied challenge means your own First Amendment violation. So let me just give you an example. Say John is sitting here and ICE comes in and bashes him. I can't sue ICE on John's behalf because I don't have standing for it. Only John can do that. In overbreadth, if he was charged with an overbroad statute, I could raise John's issues because that's what overbreadth is all about. You can raise other people's thing in order to avoid chilling the speech. So, all the Supreme Court has done was strike down an overbreadth challenge to 1324. It does not mean that if you're doing something and you get caught and are charged under 1324, that you can't raise First Amendment protections, depending on what you did. And remember, First Amendment mostly is about speech and communication, but it can also involve conduct, expressive conduct. We're thinking about like burning the American flag. That's protected by the First Amendment, it's conduct. And you can be busted for burning an American flag if you're busted for, a place where fires aren't allowed. But it has to be content neutral, it apply to everybody. If it's because you burned the American flag that you're being prosecuted, that's what violates the First Amendment. So expressive conduct can be brought in. So we still have the possibility of raising First Amendment challenges to it. So just to kind of conclude, I started out saying I didn't want to scare people. That's wrong. I'm scared myself. And I think fear is a reasonable response to the circumstances we're actually in. Courage isn't an absence of fear. Courage is understanding the fear and then overcoming it so we can do what needs to be done. And I think we can find strength in standing this make by just imagining what will happen if America goes fascist. And I'm not talking about just what will happen to us, but to the whole world. History teaches us that no empire lasts forever. But with its nuclear bombs, the United States is the first empire in history that can, if it chooses, take the rest of the world down with it. But on a positive side, we can imagine how much better the world would be if we were to change America. Establishing social justice, redistributing wealth, adopting humanitarian medical care, protecting the environment, promoting peace, are all achievable goals that are worth fighting for. To those of us who want to protect our vulnerable neighbors who are now hiding in fear, we'll each have to look inside ourselves to find the strength to do what needs to be done to prevent fascism. So in that spirit, what I say is, if you're willing to stand on this and help the most vulnerable amongst us, you actually represent what is best about America. Thank you. So we can take questions or rebuttals or anything you want.
So if we started sending out food now to people, that would be a proactive thing that we could do?
The sooner the better. The more you have a history of doing this kind of thing or link in with somebody who's been in it for a long time, the more credible it's going to be to get up there and say, no, this wasn't about ICE, this was about just helping everybody in need, and we don't care whether they're good or bad with ICE or whatsoever, we just want to feed the people that need it. Versus, if suddenly ICE comes in and raids are happening, then you start doing it, it's going to be much harder to make a case that this wasn't involving impeding ICE. So yes, I think the sooner you do it, the better. And it's on that kind of stuff, it's good not to be secret about it, because your vibes are, we're innocent, because in fact, we are, Any other questions or comments or anything? Well, good, we can go home early then.
So that's the question. If we're not being secret about it, does it also help for us to be putting things out there in regular emails and things rather than signal, or at least doing a balance between them in your.
Sure. I mean, the way it would work is if you get caught and you're in court and you're raising these kinds of issues, it's a question, what's known as a question of fact for the jury or the judge, if there's a jury, no jury trial, to decide. So as much evidence you can bring in, saying, look at here, here's emails I did, here's things, here's my witnesses who can say that. The more you can do that to establish that, the better defense you're going to have. Yeah?
I see what you're saying for the person providing the aid, but what about for the person receiving the aid?
The person receiving the aid depends on what their immigration status is, of course. You know,
In the current context of people being targeted and followed.
yeah. The way it practically works right now is it's pretty rare that they're going to be charged criminally under these kinds of statutes because they're going to be said, you're undocumented, so deportation is where they're going to go, and they're going to detain them for deportation. And there's a scary aspect of that, because there's less constitutional rights in civil proceedings than there is in criminal proceedings. So the bit about staying in the country is a civil violation means it's easier for them. And I think that's a direction that I'm afraid that the Fourth Amendment is going. I mean, the courts are going with the Fourth Amendment because it already exists for things that most of us support. You know, like tuna boats that have nets that are going to catch dolphins. You know, there's a rule for the Fourth Amendment that to search a tuna boat for whether it has the dolphin nets, you don't need the suspicion, the reasonable suspicion that you would in a criminal case. In a criminal case, you can't detain somebody. You can't even turn on your blue lights to make them stop unless you've got an articulable, reasonable suspicion. But you don't need that for doing things like checking fishing boats for their nets. Where this all started off with was fire protection. You know, with fire protection, they want to go down and find the dangerous buildings for fire. And they say, well, since that's a civil activity, you don't need the same probable cause that you would need for a criminal arrest. The probable cause that you need is only probable cause that this is the type of neighborhood in which there are dangerous fire buildings, so that we get to go into those buildings and inspect them for fire violations. So I think it's just a matter of time before the Trump Department of Justice is going to come out and say, well, actually, deportation is a civil detention, not a criminal arrest. And so the probable cause we need is the probable cause for an administrative inspection, like a fire inspection or inspecting it. And that would allow us just to go into neighborhoods where we know there are a lot of unsolicited people or a lot of people of color and things like that. That's where I think that this is going. And we're going to have to fight that to keep that from happening. But that hasn't happened yet. As a matter of fact, I was looking in here to find cases where something like what we're talking about, like providing food and things like that, have been busted under 1324. And I couldn't find any. I think the way most of the cases are working out now is, like in a sanctuary city, you know, even in a sanctuary city, ICE and the feds go in there after the undocumented. And under sanctuary principles, the local police don't help them with that. But the local police are there, and they're enforcing local laws. So if there's a crowd of demonstrators that are there, that are demonstrating against ICE, the local police, even in a sanctuary city, will arrest the demonstrators if they're doing an unlawful assembly, refusal to disperse, those kinds of things. And then they're prosecuted under state law, which we've seen quite a bit of. You know, unlawful assembly, refusal to disperse, those kinds of things that we always have dealt with forever. But it's possible, and if they want to get tough, which is my sense is that they do want to get tough, that they're going to start using this and expanding this against us. Because I think there's a vulnerability we have under this statute for the kinds of things that we want to do, which is provide food, transportation, for the ones who are in such a vulnerable position. Okay. Anything else?
Could you just speak a minute more about, you said it puts us in a vulnerable position to do the things that we're wanting to do, of supplying food and transportation?
Right, the argument that the prosecutor would use is, say there's an undocumented person, and they're scared to go out because they're afraid ICE is going to catch them. They don't want to starve to death, and we don't want them to starve to death. So we say, okay, we're going to set up a network to bring them food. The prosecutor's argument is that act of bringing them food is helping them stay in hiding, which is helping them be concealed. And they're harboring them. So we could be vulnerable to that. I mean, I think we will see some prosecutions along those lines. And it puts us in a very difficult position because, I just don't see how as humanitarians we can turn our back on this and say, well, let them starve or let them all get caught. But I don't particularly want to see you all facing 5 years in the federal penitentiary either. So it's a very careful line, which is why I thought it would be worthwhile to do a presentation like this so that people, as I said, look the beast in the eye and understand it. So we can figure out the best ways to mitigate it and at least give ourselves the best chances possible while still getting the mission done.
And what about the fact of how we are seeing the judicial system just really breaking down from how it's just getting so clogged up, that cases are just like backing up. So if we are charged, is there any hope in the sense that it'll take forever before the case gets heard? That's
possible. I mean, there is possible, like if you look at the anti-draft stuff, as the different administrations change, the politics change, a lot of people who were being prosecuted early were no longer being prosecuted. I burnt my draft card publicly, but at that time, this was like 1969, that stuff was over with because they were way too clogged and they didn't want to prosecute us. If you wanted to get prosecuted for resisting the draft, what you had to do was take your draft card and cross it out and then mail it to Selective Service to say, I'm not going to participate in that. So, times change. If say, Trump eats too many cheeseburgers and falls over, or there's a new regime comes in, all that stuff could be changed, including even people who get convicted, either getting pardoned or amnesty. Maybe not as well as the guys on January 6th got pardoned, but no, that stuff does happen. Yeah?
Is there any consideration given to the fact that a lot of these efforts are to help people who are here legally? I mean, how do they parse that if you're part of a network that's helping someone in hiding, but they're here legally?
Right. On that, to my mind, that's an absolute defense. In other words, there has to be at least someone in that building who is undocumented, who is in violation of the law, because there's nothing illegal about feeding a legal person. And that's why we say we want to be neutral on the issue of immigration status. So, most of the people we're feeding may be here legal, and there's nothing wrong with that. And we don't have to say, well, we knew he was illegal and we fed him anyway. We say, we didn't ask, we didn't care, because our role was not to help ICE or do immigration. We don't care about immigration. What we care about is humanitarian feeding the needy.
I guess it's like a cautionary question. If the Trump administration were to change the criminal, like kind of the reasoning for searching a building being a criminal concern to a civil concern, is there something that an individual who is in that building could say to refute that civil concern? Because as I understand it now, if it's on a criminal, charge, you can say, I need to see a warrant.
Oh, absolutely. I mean, that will be litigated ad nauseum. The way it would work is you get busted, you're charged, and assuming you don't plea bargain or something like that, and take it to trial, one of the first things you would do is say this was an illegal search and seizure, because in fact it was a criminal activity that they were doing. We had a case in Maine. I don't know if you follow the drunk driving stuff, but drunk driving was a criminal offense, and the prosecutors were getting frustrated with it, all the criminal rights of defendants. And since most of them weren't being sent to jail, that they talked the legislature into passing a civil violation for exactly the same thing. So the elements are exactly the same, and the prosecutor got to choose whether to prosecute civilly or criminally. And the only difference would be, is civilly, you couldn't do a jail sentence, but you could, take away licenses and all the fines and stuff. And the prosecutors would find that much easier, so they started, prosecuting people civilly rather than criminally. And the Maine Supreme Court rejected that and said, no, we're not falling for that. These are really essentially criminal cases, and defendants in OUI have the rights of a criminal defendant, and the prosecutors don't get to choose what kind of constitutional rights you're going to have. So that was a good decision. I'm not sure that the current U.S. Supreme Court would come to the same conclusion, but only time will tell on that.
The business about food, delivering food, that doesn't seem so difficult to me. You just have to somehow publicize that the service is available and people can sign up for it. But what about people who might need a trip to the hospital for a test, or get medication, or they're worried about escorting their children to and from school? That seems trickier to me, because why are you doing that? If you could set up a
There's something to that,
service.
but there's also something that would be just the opposite. That in those types of situations, there's more of an emergency and more of a justification to take them to the hospital if they're dying, to say that you can't do that. There is a case I found where an employer was giving transportation to his employees who were undocumented to work. And they said that didn't violate it because there's no criminal intent there. If you're doing something like taking somebody to the hospital, it seems to me you might be even stronger grounds to say, I wasn't doing this to impede ICE or screw up our immigration system. I was doing this because the poor person was dying.
Or just to go to a doctor's appointment.
Yeah.
So to prevent them from dying. Right? Doctor's appointment.
Yeah, all these things are very fact specific, but what it gets down to is it evidence that you had the criminal intent? And here Hansen is the case that they had crazy reasoning there.
Yeah, it seems pretty weird to
As
me.
Jackson's dissent starts off saying, it's strange to be interpreting a statute and not starting off with the words in the statute. they ignored that. And it's a special thing I meant to highlight it when I did the overbreadth stuff. Remember, the rationale for overbreadth is if you allow overly broad statutes to exist, then some innocent people there who might want to speak will read that statute and say, oh, that statute is overbroad, it can apply to me, so I'm not going to speak. And they say, we want a marketplace of ideas and encourage people to speak. Then they come out with a decision that says, to understand that there has to be criminal intent here, you have to know the specialized criminal law language and not use the ordinary language. So an ordinary person who reads that statute would think that's overbroad and would be chilled by it, unless they go to a lawyer and say, oh no, don't worry about it. They really have to show solicitation and facilitation, and that requires criminal intent. So you have a really kind of circular kind of reasoning there, but there's nothing unusual about that in the legal thing.
Well, I may be dense, but so this whole Hansen thing. So he scammed all these people, right?
Right.
And then he was charged for something?
Yes.
He was charged with what?
He was charged with 1324 for encouraging people to come into the country illegally. Because he told them, if you pay me $5,000 and I line you up with an adult adoption by an adult American,
Okay.
You can come into the country. And a lot of them did come into the country.
Right, okay. So then, what was, so was he let off? Was he convicted? I
He
mean,
was-
that's a lot of legalese there, So
I know, I apologize, there's just nothing I can do about the legalese. He was charged, he was convicted below, he appealed up to the Ninth Circuit Court of Appeals, claiming that the statute was overly broad, and therefore, even though he could be charged under this, the statute had to be thrown out under overbreadth grounds, and he won in the Ninth Circuit, which meant he would go home. But the government then appealed it to the U.S. Supreme Court, and the U.S. Supreme Court saying that the Ninth Circuit had stacked the deck. It didn't give a fair shake to the specialized language, ruled that 1324 was not overbroad, and therefore Hansen failed, so his conviction was reimposed, and he's probably still in jail, I think.
Oh, okay. Thank you.
It doesn't break my heart that he's in jail, but.
And so he is our hero, why?
I was being sarcastic then. But because, you know, he was the one raising the First Amendment. Usually we think when somebody raises a First Amendment case, it's because they believe in the First Amendment and, you know, they're kind of on our side or something like that. He was in a very desperate situation and he just grasped at this to pretend to be a First Amendment thing for anything that could possibly get him out. Because when you're in that type of situation, you'll make any argument you can. Okay? Well, I thank you all for coming, and I hope you have a